All right, counsel, would you like to make an opening statement at this time?
Judge, just so I think to make it clear, this is really on a limited issue of a UIFSA objection. And so I anticipate, considering that we have these stipulations on the exhibits, that the majority of this will be argument. I do have the exhibits pulled up and I can walk through them, but I think that if the court's okay with this, I can just start into our argument as it relates to our objections.
Sure. Attorney Rewalk?
Well, I agree that this should be primarily legal argument, Your Honor.
Okay.
I can make an opening or just wait for my turn. Either way, however you prefer to run it. I do want to point out that we did file an answer to Mr. Muse's motion to abate.
This isn't just a routine courtroom exchange. It's a legal chess match spanning multiple states, conflicting interpretations of the law, and one critical question. What actually counts as a child support order? On one side, a father arguing that Texas has no authority to touch this case. On the other, a mother insisting this is a brand new support battle that belongs right here. At the center of it all, a dense legal framework that could completely change where and how this case is decided. And as both attorneys clash over statutes, prior rulings, and the fine print of a divorce decree, one thing becomes clear. This isn't just about money. It's about jurisdiction, strategy, and who controls the playing field. Stay with us because the smallest legal detail here could decide everything.
This morning, that has now been accepted by the court. So just wanted to draw your attention to that. And I can't provide an envelope number, but it looks like it has been accepted.
Yes, it has. Are you referring to the response to the motion to abate?
Correct, Your Honor.
Yes, I have it. And the court takes judicial notice of all contents of the court's file.
Great. Thank you, Your Honor.
You're welcome. Attorney Muse, you may proceed.
Thank you, Judge. As I mentioned, Your Honor, this is stemming from our objections related to the UIFSA pleadings we have, both in the special appearance and the plea to the jurisdiction judge. As set out in our Fathers 2, which is a summary exhibit that lays out just high level some of the events that have occurred since the divorce, and then also just a legal argument summary highlighting the relevant statutes and case law, and then some exhibits or excerpts from the party's divorce decree that are relevant here, Judge. And I'm happy to pull that up on the screen. I don't know if Your Honor has that accessible. But starting, these folks divorced in 2015 in Nevada. That is where their divorce decree, last order in this case, is out of. Following divorce, my client's father moved to Salt Lake City. That's where he continues to reside. He has never resided in Texas, Judge. On or about June of 2023, mom moved with both the children that are the subject of this suit to Texas, to the Dallas area here. That was, and my client will show, in violation of that prior order, in the sense there was no prior agreement for that move. But again, that's neither here nor there as it relates to these UIFSA objections. From June of 23 to present, my client admits that yes, he has come to Texas for the purpose of exercising possession, but that is his contact with the state. And there's case law cited in our response, as well as our initial special appearance that sets out even Dallas cases. I think it's the Cunningham case, that visitance by the non-resident's father in Texas, that's insufficient to establish personal jurisdiction alone. But as I'll highlight, I don't even think we need to get to the personal jurisdiction issue here because UIFSA simply does not apply. So mom in the fall filed this suit to modify, asking the court to modify, among other things, the support obligations in the divorce decree. We timely filed this special appearance, had the hearing, and the associate judge denied our objections under UIFSA. Now, getting to the meat of our argument, Judge, and this is on page 2 of our summary, we really do not have to go past the plain reading of the statute, excuse me, to show that our UIFSA objections should be granted and that mom has to pursue any kind of child support modification in Utah, where my client resides. And the relevant section here is 159.611. And there's really two ways that this court would have jurisdiction on this UIFSA issue, and neither of them are applicable. And the main points there is because my client is not the petitioner here, and he has not consented to this modification. And 159.611A lists a handful of ways the court can get there. Again, one of them has to be that my client moved the court for this modification. And subsection 2 of that offers another route, but it requires my client to consent to the modification. Clearly has not by the objections and the reason why we're before your honor. Now, where Ms. Boyer and her counsel have tried to hinge their argument here is, and again, I understand Ms. Boyer is making her argument, her counsel's doing his job, but I think the reason why we're here before your honor is when we had this hearing in front of Judge Lee, Mr. Rewalk and his counsel were there in person. My client, again, resides in Utah. We were remote. Without any kind of briefing, he handed the court one case out of Fort Worth that simply said that if there's no support orders, then this should be looked at as an original action. And I believe, and again, all you great judges, you don't tell us why you rule. Judge Lee's in that category, so she didn't tell us why. But that, I think, reading the tea leaves, I think that's what likely hinged this issue. And so Ms. Boyer and her counsel are looking at this as should be an original order for support. And that's simply just not the case here, Judge. And I'll get into TB and why that reliance on that is flawed. But if the court looks at the decree, and I've got those excerpts in that summary exhibit Fathers 2, I mean, there are 20 pages of support orders in this decree, Judge. And I can share my screen here just briefly to walk through it. High level, again, the prior order did not require any month-to-month support, as we would think of traditional support, because the parties were doing a 50-50 plan. But the court specifically ordered in that Nevada decree that if either party relocates, then there would be an automatic adjustment under the Nevada guidelines. There was orders for wage withholdings. There was terms for collections of arrearages. And I think very critically here, there was very much akin to our Texas orders, detailed language on healthcare orders, including the orders to maintain insurance and detailed orders for split of out-of-pocket medical support, dental, orthodontic, surgery, etc. There was also orders for the parties to share cost in lieu of child support, which was supported by Nevada statute. And there was a laundry list of those as well. So daycare costs, the kids were much younger then, educational costs, extracurriculars, necessary expenses, etc. And then I think also critical here, on one of the last pages of the decree and the support order, the Nevada order set out that there would be a statutory review for modification every 3 years upon changed circumstances. Again, very similar to Texas orders. And kind of skimming through, and we don't have to read every word here, but I've attached also the excerpts that back up that summary here. And so all of these highlights here indicate every area where we've got support orders in this judgment. Again, very detailed reimbursement for out-of-pockets, reimbursements for the laundry list that I went through, orders for health, education, financial support, extracurriculars. And then again, here in the very last excerpt, that pursuant to Nevada statute, again, allowance for review would indicate that this was a final order subject to modification. Similar to if we entered an order in Texas that said, these parties are splitting time, no monthly support. Hey, if there's a change in circumstances, we can always modify that, of course. Now, again, that being the case and defined under the UIFSA statutes, that is a defined support order. And again, I think that counsel attempted or is somewhat misleading here in the briefs that have been filed and the way that this in-rate TB was presented to the court. After we had our exhibit conference with Judge Lee, Mr. Rewalk and his counsel filed this last brief. Again, it was going to our motion to abate, which is not what's set before your honor today. But I think as just another indication, again, of somewhat of the misleading of the court here, Mr. Rewalk set out the statute here that defines support order in this brief. Now, that top paragraph is what is from his motion. And it says that a support order is defined as judgment, decree, directive, for the benefit of a child that provides for monetary support. And that's going to be where their argument is going to go today, Judge, is that there wasn't that month to month. But interestingly enough, this is the actual statute. And all of the green is what Mr. Rewalk left out of his brief. And so a support order doesn't mean just, hey, if the parties were ordered to pay what we would think of as guideline support, but it also means healthcare, arrearages, retroactive support, reimbursement for financial assistance, i.e. all those extracurricular costs. And the terms also can be related to cost, fees, income withholding, again, all included in that decree, and automatic adjustment, also included in that decree, where the language in the order stated if somebody moves out of state, then it would be child support pursuant to the Nevada guidelines. So I do take issue with the way that this has been presented to the court, and I think that's part of the reason why we're here, Judge, and having to do this de novo. Now, their critical case, which is this In-Ray TV, Judge, it's a Fort Worth case. In that case, and this is really where they rely wholly on, the other case that they cited in their brief this morning, which I had a chance to review, is totally inapplicable. It's a Mexico order. The Court of Appeals basically said Sinaloa is not even a state, so UIFSA doesn't apply. So I'll get into that if I need to, but I don't think that one is even worth touching on. But In-Ray TV, the only thing that was ordered in that case, and this was a Florida order that the Texas court was reviewing, was that father was obligated to pay travel expenses for himself and the kids. That was it. And so the Fort Worth Court of Appeals said, that's not a support order because he's basically just paying for his own plane ticket here. What's very interesting, though, is that same court that, again, Ms. Boyer relies on spelled out our exact argument, which is the definition of a support order. And the court said because it did not order healthcare, arrearages, reimbursement for financial assistance, all of the things that Mr. Rewalk left out of the statute in his brief, the Court of Appeals in Fort Worth said if that was in there, then it would be a support order, and this section of UIFSA that we're leaning on would apply. And so here, the decree again provides for monetary support. It provides for healthcare. It provides for arrearage recoupment. It provides for reimbursement of out-of-pocket costs, healthcare, and those daycare, extracurricular, educational, et cetera. It says, all necessary expenses have to be paid. And then I think critically, it said, hey, this is a judgment that can be reviewed and modified. And we allow under Nevada law, as we do in Texas, a 3-year period where it would be a mandatory review. And so all of those terms in the divorce decree, Judge, meet the definition of a support order under UIFSA. And because of that, then that 159.611 applies. And because that applies, again, my client didn't move this court and he's not consenting to it. And so Ms. Boyer has to go to Utah to modify this order where there is personal jurisdiction and where my client resides. Now, again, I think that gets us there and the court should grant this relief. But if the judge looks at it from the vantage point of Ms. Boyer, she's not saying that UIFSA doesn't apply. It's just that this is an original action, not a modification. And if that's the case, then the court still needs personal jurisdiction over my client. And that is not here, Judge. And the exhibits that have been admitted clearly establish my client's residence and domicile in the state of Utah. I don't think that's argued or really being pushed back on. I think that what Ms. Boyer is arguing is that, well, my client came here, stayed here with the kids, even stayed at her house. He did some remote work via Zoom. He did some webinars here while he was exercising his possession. And therefore, he is succumbed to the jurisdiction of Texas. Now, the Cunningham case that I mentioned earlier says the exact opposite. There's the Dallas County case. Says dad comes here just to visit. That's not personal jurisdiction. He's got to have actual ties to Texas. Lives here, does business here, and that's just not the case. And I don't think that Ms. Boyer would even allege that was. And so again, Judge, either way you look at this, whether it's a modification or original action, I think UIFSA applies, and this needs to be an issue that's out of this court and handled in Utah where my client resides, Your Honor. And I'll reserve whatever little time I have for maybe some rebuttal argument.
Thank you, counsel. You have 2 minutes and 15 seconds left. Attorney Rewalk.
Thank you, Your Honor. Where I do have an agreement with Mr. Muse on what he recited there is that we have, more or less boiled this down to whether or not Section 611 applies. And, we believe it's clear that it does not. And Judge Lee agreed with us when we presented in re-TB along with the facts of this case, Your Honor. But let me start with some of the things that I don't believe were accurate at all with Mr. Muse's presentation. One, the contacts with Texas for Mr. Yu. Now, that's outside the scope of the 611 argument I'll be making, the modification versus original child support order argument. But he, and you'll see in the text messages that we submitted as exhibits, has come to Texas just for work, not just for the purpose of exercising possession with the children. He's spent a significant amount of time in Texas, not just flying in, picking up the kids and leaving, but staying for extended periods of time at my client's residence. So we believe that there are sufficient contacts with Texas. That aside, Your Honor, regarding the legal arguments regarding 611 and whether it applies or not, the statute outlines what a qualifying order would be. That was read by Judge Lee. You're very capable of reading it too. We only included snippets in our filing today, just for the purposes of saving time. We're not at all trying to hide anything from the court on this. What's important about the wording of that statute, Your Honor, is that it requires some of those expenses being paid by an obligor or to an obligee or in place of child support. And the Nevada order simply does not do that. Mr. Muse went through all of this recitation about what is in the Nevada order, but that's just not accurate. First of all, the Nevada order is 14 pages long. Everything after that is an exhibit attachment, which is the divorce petition, not the divorce order. So any reference to anything beyond page 14 is simply not part of the order at all. Beyond that, Your Honor, the wording in the Nevada order matches the wording used in that case in re-TB, which is based on the party circumstances, neither party shall be obligated to pay child support to the other. Now, what exists in the Nevada order, as well as that, regarding any cost sharing, none of it is specific, Your Honor. None of it is without condition. So, for example, the wording in the other expenses ordered in Nevada, and I'll share my screen so Your Honor can see this exactly. Very unspecific. There are no terms in here for the sharing of those expenses. Where we have the healthcare terms appears later, Your Honor, on page I apologize, Your Honor, the bottom of page 6 on the Nevada order, which is really the only section that deals with any cost sharing at all, says that Tina shall continue to provide health insurance as long as it's available through her employment. That is contingent and depending on whether that is available to her. It is not specific enough. It provides for no contingency for what happens if it is not available to her. Nothing in this order considers either party an obligor nor an obligee. And that is the wording of the statute that Mr. Muse was quoting, section 28 of 159.102. None of it is in place of child support. There is no obligor. There is no obligee. There is nothing in the Nevada decree that says what happens if insurance is not available through her employment. There are no procedures or reimbursement processes, no order language whatsoever regarding those additional costs that are aspirationally told to be split between the two parties. So does it tangentially address child support? Yes. Does it provide a comprehensive medical support order? No. That is where the case that Mr. Muse said was not relevant really is relevant, which is in re VLC, which is cited in the brief that we filed this morning, Your Honor. That's 225 Southwest 3rd, 221 from 2006, where in that order, the court was specifically interpreting UIFSA and this same section and whether or not there was an existing order. And in that order, the father was ordered to pay all medical expenses, but it was conditioned on the agreement between he and the mother. And that is what we have a much more similar order in Nevada to that order, in that it is contingent or not laid out in any detail with order language that creates an obligor and an obligee. We simply don't have that. Nothing in this Nevada order actually dictates any monthly payments from one party to the other. Where we're talking about child support in the future, it doesn't say who would pay child support to the other party in the future. It doesn't say how much. They have to go back to court and establish that order if one of the parties moved. And that never happened. So this is simply not a qualifying child support order under UIFSA. And for that reason, we're asking you to uphold the ruling from Judge Lee on this. This case is already going in front of Judge Lee for purposes of conservatorship and possession under UCC JEA. It makes no sense for the parties to have to go to Utah to fight this on two different fronts. The reason we're here to answer the first question Mr. Muse asked is because the father in this case doesn't want to pay child support or wants to pay it at a lower rate that would be available to him in Utah, or wants to push this as far down the road as possible. The fact is, this order uses the same language as the TB case, which is no child support is ordered paid by either party. It doesn't order either one of them to reimburse the other for health insurance premiums. Whatever costs are referenced are not actually ordered paid by either one, with no procedures laid out for how that would happen. And when we regard the health insurance premiums, that also is condition language on it being available. And again, it's not, there's no detail whatsoever about what would happen if it becomes unavailable, on who would pay for it, on how that would be split, on any procedures like that, on any money changing hands between the two of them. What exists only is the unreimbursed healthcare expenses issue, which is a cost sharing issue, which is also addressed in TB, which is the cost allocation on the travel costs. That's not the same thing as a support order. It's not the same thing as a support order under UIFSA. And therefore, this is a brand new child support, it would be a brand new child support order, not a modification of one. There's no obligee, there's no obligor, and we're trying to establish that. That would have to be established originally. It wasn't in any sense according to the Nevada order. And there are just not any details. If the court reads the terms of the Nevada order, Mr. Muse presents them as detailed, comprehensive orders, and they're just not that at all. Compare the health insurance section of this Nevada order to what we have in Texas, where there are procedures in place on reimbursement for premiums and what happens if it becomes unavailable, and who is going to be responsible for that, and who is the obligor. And that simply doesn't exist in any meaningful sense in this Nevada decree. And of course, the main point, which is that the specific rationale of INRI TB, which is neither party shall pay child support to the other, is the exact same language as this Nevada decree. They're asking that the court consider this a modification when there's nothing to modify. There's nothing in place. There's not enough terms in there to be a specific and comprehensive order. And for those reasons, Your Honor, we ask that you uphold Judge Lee's decision in which he took INRI TB into account.
Thank
And I'll
you.
reserve the remainder of my time.
Okay, and you have 6 minutes and 4 seconds left. Attorney Muse, a response?
Yes, Judge. I mean, one thing that caught my attention in Mr. Rewalk's argument there is that this doesn't make sense in the sense that how UIFSA is set up to where Ms. Boyer would need to seek this modification in Utah. Now, that may be his opinion. It's not the opinion of the 50 states of this union. I mean, that is the purpose of UIFSA, is to seek personal obligations where the party resides and where personal jurisdiction attaches. And there's a specific mechanism that has been adopted nationwide on how to address that. And Mr. Rewalk and his client are simply just trying to ignore that structure. But I think going back to the statute comparison, which again, Mr. Rewalk and his client cut out half, if not more, of what is defined as a support order. You know, what they are focusing on is this monetary support language. And again, I would still argue that, as we see all the time, Judge, when you have a 50-50, if no month-to-month support is paid, that doesn't mean that no support order was rendered. It simply means that based on the circumstances at the time, no cash monthly support was ordered. But I don't even think that, even if the court buys their argument, Again, they're disregarding healthcare, arrearages, retroactive support, and the clear or in this paragraph means that any of these things equals a support order. And when you look at the order language, and again, I do disagree, with Mr. Rewalk, there are extensive terms in here on how these parties are to share these costs. And again, a support order can be for the benefit of a child or a former spouse. And so when there is a reimbursement structure that sets out, parent has to receive written request, contribution out of pocket. They have 30 days to reimburse. That, again, it's very much akin to the detailed orders we have. That is a support order. And so this reliance on TB, I think, is completely misguided because, again, it supports our case, not theirs. Because the Fort Worth Court of Appeals said plane tickets for dad to go fly, that's not support. That's just that's like gas in your car. But a detailed order, and this is what TB said, that said healthcare, support, out-of-pocket costs, those things are a support order. And that is what we have here. And there is specific mandate language. It's ordered, adjudged, and decreed. This is how these parties are to exchange these costs, Judge. And so we think this is clearly a support order. 159-611 does not apply for Ms. Boyer. And so the court has to order this to be pursued where my client lives.
Thank you, counsel. And you just ran out of time.
Yes, Judge.
Attorney Rewalk.
Thank you, Your Honor. And so much of what Mr. Muse said is just not correct. There's one section of any detail whatsoever, which is the procedure for exchanging information regarding unreimbursed expenses. That is not a comprehensive support order. Again, these exact wording for the health insurance section, which again is pages and pages long in a Texas order, says, TINA shall continue to provide minor children with health insurance coverage so long as it's available through her employment. And that is it. That is all in terms, that is all it covers at all in terms of health insurance premiums. It doesn't include anything else, any contingencies if she doesn't do it. When it comes to the other expenses, it is not at all comprehensive either. Here is the exact wording of it. Without order language, it says, in addition, the parties shall share equally in all expenses involving health insurance for the minor children, daycare costs associated to the minor children, educational costs, extracurricular costs, and any other necessary expenses. And that's it, without any additional procedure, without any guidance on how those myriad of additional costs are to be allocated. Without that, Your Honor, it is just simply not a comprehensive order for support or medical support. It is cost sharing akin to TB. The case in Mexico or involving the Mexican decree is not for the purposes of the end result of the case, Your Honor. It's the interpretation of the fact that you had a conditional order regarding child medical support, and that's what we have here. It's conditional upon whether or not it's available to Ms. Boyer. And that's all it says. And that is the purpose of INRI VLC, Your Honor, which we believe is particularly on point for this. INRI TB, they keep saying that it's not applicable or nothing like that. But what they haven't done, Your Honor, is point you to any contrary court case law that supports their position on this. Again, neither parent will pay child support to the other. Exact same language as what we have here. There is no obligor, there is no obligee. And he just glosses over that part of the statute of 159.102. Again, who is the obligee? Who is the obligor in this decree? It just doesn't exist at all. And none of it is in place of child support. It's simply a way to allocate costs in the way that TB did regarding travel costs. Again, not comprehensive, no support paid, no monthly amount going from one side to the other. Every part of that contingent or not laid out in any detail that would ever be enforceable. And again, just not equating to a comprehensive order that would qualify under UIFSA. We understand why UIFSA exists. We're not fighting the existence of UIFSA. We're saying that under UIFSA's own definition, that this does not qualify as an existing child support order. And for that reason, we have to consider this a brand new suit. And that's what we're asking to do, is simply uphold the decision that's already been made so these parties can move forward with this and get resolution on it. Again, sharing costs is all this does in a non-specific way. the other costs referenced, there's just no mechanism for any money to change hands at all. Not a support under UIFSA. Thank you, Your Honor.
Thank you. So in Judge Lee's associate judge's report, she said that she was going to conference with the Nevada court. But from what I'm hearing, neither one of you are you saying, or either of you saying that Nevada is the appropriate court?
No,
The
Your Honor, I
conference
don't think.
Okay.
I was just gonna say the conference was related to the UCCJA issues, and so we're moving forward on the custody portion. It's just the support issue that we're dispute over. So that I think is water under the bridge at this point.
Right, and everyone's acknowledging that no one lives in Nevada anymore, and that under the UCCJA jurisdiction is proper in Texas.
Okay, so you all are talking about UIFSA related to okay, I got it. So father is arguing that the Utah court is the appropriate court.
Yes, Judge.
Okay. I just want to make sure I follow. So what the court is going to do is to take this under advisement. I want to have the opportunity to read over the Cunningham case as well as the TB case and some of the other cases that you both cited in your relief and your responses. So I'll take it under advisement and I'll get you all a ruling out next week.
Yes, Judge.
Thank you, Your Honor.
all.
Thank you, Judge.
You're
We're
welcome.
excused.
Have a good day. Yeah.
What we've just witnessed is a textbook example of how complex and technical family law can become, especially when multiple states are involved. At its core, this case hinges on a deceptively simple question. Was there ever a true child support order in place? One side argued that detailed cost-sharing and healthcare provisions meet the legal definition, while the other insisted those terms are too vague and conditional to qualify. The judge, recognizing the weight of that decision, chose not to rush, taking the matter under advisement to carefully review key cases and statutes before issuing a ruling. And that decision could determine not just how this case proceeds, but where it's fought altogether. Now we want to hear from you. Do you think this should be treated as a modification or a completely new case? And which side made the stronger legal argument? If you found this case as fascinating as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.